As of 2026, what unsettles global high society is not rumor. It is documentation. Deposition transcripts, compliance emails, suspicious activity reports, visitor logs, flight manifests, internal memoranda, surveillance records. When Jeffrey Epstein died in August 2019 inside the Metropolitan Correctional Center in Manhattan, the prevailing assumption was that the full scope of his network would never be tested in court. A criminal trial would not proceed. Cross-examination would never occur. The architecture of proximity would remain partially obscured. Yet, between 2024 and 2026, court-ordered unsealings and Department of Justice disclosures fundamentally altered the public record. Millions of pages of documents, along with thousands of images and video files, were released in phases. What media outlets loosely called the Epstein list was not a definitive roster of wrongdoing. It was something structurally more revealing, a map of associations. Names appearing in logs, contacts recorded in address books, email exchanges, scheduling notes. Not proof of guilt, but proof of connection. The impact was cumulative. Resignations followed. Corporate boards responded. Public officials revised previous statements. European and American political circles faced renewed scrutiny. The narrative shifted from, how did so many systems fail to interrupt it? In 1974, despite lacking a completed university degree, Jeffrey Epstein secured a teaching position at the Dalton School, one of Manhattan's most prestigious private institutions. His academic credentials were later determined to be falsified. Dalton functioned not merely as an educational institution, but as a social gateway into elite New York networks. Epstein's unconventional teaching style, informal, boundary testing, and socially strategic, brought him into contact with affluent parents and influential families. Concerns regarding professional boundaries eventually emerged. His employment ended in 1976. Yet, the termination did not produce reputational collapse. Instead, it enabled transition. Through relationships formed within Dalton's parent community, Epstein entered Wall Street, joining Bear Stearns. Questions regarding his educational background resurfaced, but performance metrics and revenue generation reportedly overshadowed credential discrepancies. From the outset, a pattern became visible. Access, adaptation, network leverage, retention. Authority did not depend on institutional validation alone. It depended on perceived utility. The deregulatory climate of the 1980s created fertile ground for opaque financial arrangements. During this period, Epstein transitioned into managing wealth for ultra-high net worth individuals. The mechanics of his wealth accumulation remain partially unclear in public records. What is verifiable is that he cultivated relationships spanning finance, academia, politics, and royalty. By the early 2000s, law enforcement investigations in Florida uncovered allegations of sexual abuse involving minors. In 2008, Alexander Acosta, then U.S. Attorney for the Southern District of Florida, negotiated a non-prosecution agreement. Despite numerous identified victims, federal prosecution was deferred. Epstein pleaded guilty to state charges and served 13 months in county jail with extensive work release privileges. Critically, victims were not adequately informed of the agreement's terms. Years later, this omission would become central to public controversy. In 2019, amid renewed scrutiny, Acosta resigned from his position as U.S. Secretary of Labor. The 2008 agreement stands as one of the most consequential institutional decisions in the case, illustrating how prosecutorial discretion, when exercised with limited transparency, can reshape accountability trajectories. Epstein's properties were operational spaces: a Manhattan townhouse on the Upper East Side, a Palm Beach estate, a ranch in New Mexico, the private island of Little St. James. These sites functioned as curated environments for hosting influential guests. They provided privacy, exclusivity, and insulation from conventional scrutiny. Central to this ecosystem was Ghislaine Maxwell, who became closely associated with Epstein beginning in the early 1990s. Federal trial testimony later described Maxwell as facilitating introductions and recruiting young women under the pretense of mentorship and opportunity. In 2021, Maxwell was convicted on federal sex trafficking conspiracy charges and sentenced to 20 years in prison. Her conviction underscored two realities simultaneously. The system could still impose accountability. That accountability arrived after decades of operational latitude. Civil litigation shifted attention toward banking relationships. Internal compliance reports at JPMorgan Chase flagged unusual transaction patterns linked to Epstein over many years, including significant cash withdrawals and payments to young women. Suspicious activity reports were filed, yet the banking relationship persisted. Between 2023 and 2024, JPMorgan agreed to pay approximately $290 million to settle litigation brought by victims. Deutsche Bank reached a settlement of approximately $75 million. These agreements did not constitute admissions of criminal wrongdoing. However, they raised structural questions. At what threshold does reputational risk outweigh client profitability? How does compliance escalate concerns involving high-value clients? What institutional incentives discourage termination? The case expanded from personal misconduct to systemic tolerance. In July 2019, the U.S. Attorney's Office for the Southern District of New York unsealed a new federal indictment charging Epstein with sex trafficking and conspiracy. The move effectively sought to bypass the protective boundaries of the 2008 NPA. Then U.S. Attorney Geoffrey Berman oversaw the prosecution. His office's action represented a significant institutional counterforce, an attempt to reassert federal authority despite earlier agreements. Epstein's death weeks later halted the criminal trial. Berman himself was later dismissed in a separate controversy, prompting political scrutiny. Regardless of subsequent events, the 2019 indictment remains a pivotal institutional response. On August 10, 2019, Epstein was found dead in his cell at the Metropolitan Correctional Center. The official ruling? Suicide. Subsequent investigations documented multiple procedural failures: non-functional surveillance cameras, guards failing to conduct required checks, falsified logs, removal from suicide watch despite prior concerns. Correctional officers were later charged for record falsification. Whether interpreted as negligence or systemic dysfunction, the episode exposed weaknesses in federal detention management, particularly concerning high-profile detainees. His death prevented a public trial. It did not prevent documentation from surfacing. Between 2024 and 2026, federal courts and the Department of Justice oversaw the phased release of millions of pages of documents connected to Epstein-related proceedings. The disclosures included extensive deposition transcripts, financial records, visitor logs, thousands of photographs and video files. The volume was unprecedented in modern high-profile criminal litigation. The consequences were immediate. In 2026, Thomas Pritzker stepped down as executive chairman of Hyatt Hotels after previously undisclosed interactions with Epstein and Maxwell surfaced in released documents. While no criminal wrongdoing was alleged, he publicly described his past judgment as deeply flawed. The episode demonstrated a new phase of reputational accountability, driven by documentary exposure rather than indictment. High-level public officials acknowledged past contact with Epstein after documents contradicted earlier denials. The issue was not criminal charge, but credibility erosion. Released records included repeated references to prominent political figures, appearing in flight logs, contact lists, or communications. Such references do not establish criminal conduct. However, their recurrence intensified public scrutiny. In the United Kingdom, senior political figures faced renewed examination following publication of historical communications with Epstein. The case became transnational, not through conspiracy, but through documented association. The scale of document release also triggered debate over privacy safeguards. In some instances, victims' identities were insufficiently redacted in publicly accessible files, raising ethical and procedural concerns. Transparency had expanded, but so had questions about how transparency is administered. While criminal prosecution ended with Epstein's death, civil litigation continued. Survivors, including Virginia Giuffre, pursued legal action against influential individuals. One high-profile case concluded in a substantial settlement involving Prince Andrew, who denied the allegations. Civil proceedings relied heavily on documentation, flight logs, calendars, contact books, demonstrating that institutional records can outlast individuals. The durability of data became a form of structural counterweight. The Epstein case is frequently described as the story of a predator embedded in elite society. But the deeper narrative concerns institutional permeability. A school failed credential verification. A prosecutorial office negotiated secrecy. Banks maintained profitable relationships amid compliance concerns. A correctional facility failed protocol. Public officials revised earlier statements under documentary scrutiny. Corporate leaders resigned following record disclosures. Each failure, viewed independently, appears manageable. Viewed collectively, they form architecture. Jeffrey Epstein did not invent the system. He navigated its blind spots. As of 2026, the enduring question is not who appeared in a logbook. It is how many institutions required documentary exposure before recalibration occurred. Not rumor, not conjecture, record. Thank you for watching.